Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Now, without any further ado, it's my pleasure to introduce our speaker for this session, Stacie Hausner. Stacie has mediated thousands of cases in the areas of personal injury, civil rights, employment, business, real estate, insurance coverage, construction defect, malpractice, and entertainment. She's been a mediator for 10 years and an attorney for 27 years and has an LLM in dispute resolution and has been teaching mediation at Pepperdine Law School for the last 8 years. And has been training mediators through the Central District Courts panel for mediators for the federal courts as well. The Mediating and Litigated Case Program at the Strauss Institute and many other mediation organizations. So we could not be in better hands to learn about mediation and settlement techniques. Thank you so much for joining us today, Stacie, and I will hand it over to you.
Well, thank you, Katie. It's such an honor to be here with you all. And I love these little emojis that are floating up, like the thumbs up and the hearts and stuff. So thank you for that. I love that. Oh, I'm getting more. Okay, well, hello, I'm Stacie Hausner, as Katie said. I hope you all have been enjoying this day of MCLE programming. And more importantly, I hope you all and your families are safe during this awful devastation from the fire. I really do. I wish you all the best. I am excited to talk to you about the art of settlement, techniques you can use to enhance your settlement outcomes. And having mediated thousands of disputes over the last 10 years and having taught negotiation and mediation for the last 8 years at Pepperdine Law School, it becomes very clear that certain approaches to settlement really can optimize your settlement outcome and enhance your client's satisfaction. So I want to spend the next hour or so with you discussing ways that we can do this. Next. Okay, so let's jump right in. This program will discuss what you can do before, during, and after the mediation. I think most of us mediators agree that preparation is key. Let's go to the next slide. Preparation is key. So I know this seems so obvious. Not every lawyer does this, so I just want to say we really can tell when you're well prepared, and it really helps your client. And I tell mediators, I do a lot of training of mediators, I tell them this too, the more prepared they are with the case, the better as well. So let's start by talking about what we can do to get our mediations well prepared and enhance our outcomes. So next slide, please. So the first thing I want to bring up is to know your case. And this too seems obvious. Let me be a little more specific with this. Knowing about your evidence is really important and how it supports your narrative of the dispute. This can help us mediators convey the strength of your position and also push back on the other side. So it's good if you know what the deponent actually said. It's good if you know what the emails say. It's good if you know what the documents say. Those lawyers that are armed and ready to go with this information really have a pushback for us on the narrative that the other side is talking about. Knowing what undeposed witnesses are going to say, that can help us as well. Knowing your BATNA. So that is your best alternative to a negotiated agreement. So what is it going to look like for your client if you do not settle today? What's a future mediation going to look like? Are we ever going to be able to get this type of a deal again? Are they going to have to spend a couple $100,000 more in litigation expenses? What will that alternative look like? Also, what is trial going to look like? We all know that we never know what could happen at trial because it's strangers deciding the case. So what is that risk and cost structure going to look like? I say to know this because it's going to help you evaluate your settlement. What is the settlement value of the case? And cost and risk need to be part of that analysis. So really pay attention, spend some time at analyzing with your clients what an alternative to settlement looks like. Knowing comparative verdicts and comparative settlements can be very helpful. That helps set your settlement evaluation. It also is a good persuasive technique in getting the other side to give you what you want. So if you know shoulder surgeries typically are awarded this amount, or disability discrimination cases in this industry are awarded this amount, those can have persuasive impact, but also can help you try to create your settlement evaluation of the case. And then obviously your costs and risks should be taken into account. How much are experts? How many experts do you need? Are you a 50-50 chance of winning? Is liability clear? All of this should go into your settlement evaluation that you discuss with your client before you even get to the mediation. Okay, timing of mediation matters. I think you all know this. Early mediation, great. We have no attorney's fees or very low attorney's fees at this, especially if it's pre-lit. That's fantastic because defense and plaintiff want to recoup attorney's fees. So that creates a larger gap for us to bridge for settlement. So early can be advantageous. Early also could be advantageous because of the uncertainty of it. So you may not want to disturb your whole workplace and make everyone sit for depositions, and we don't really know what someone's going to say. Once we know what somebody's saying, then one side may love it and their evaluation may change. So coming in early can be a benefit in that we just don't know at this point. Some of you want to and like to have mediation where you have a dispositive motion pending. I had one last week. It was a pretty strong dispositive motion, and the defense was hoping that that would bring plaintiff settlement evaluation down. So consider having your mediations during the pendency of one of these types of motions. The other people like to have it late. The problem with that, obviously, is we have a lot of litigation costs, and plaintiff want to recoup it, and defense wants to give less money because they've spent all of this. But sometimes we just need discovery. We just need to know what the experts are going to say. We need this to pan out a little bit to see if both sides can evaluate the case more similarly. So keep in mind the timing of the mediation as you decide when to mediate. Selection of mediator, I always say you might want to consider letting the other side select. That means this mediator has some persuasive power on that side that's selecting. You know that they trust that mediator. You can look up the mediator, you can put it through your listserv, see if that mediator could work for you, especially when you know your evaluation of the case. The other thing with selecting mediator, think about who the attorney is on the other side and who your client is and the other side client. Do they need a strong judge to come in with an evaluation to listen? Do they need a skilled mediator who knows how to work a mediation and is nurturing and empathetic? Do you think about what is needed? Do you need someone who's done 100 HOA cases because they know how to find creative resolutions in this space? So think about what's going to be best for your case and select accordingly. Another thing I always tell lawyers is do not hide the ball. So let me give insurance companies, for example. They need information in their files to justify paying certain amounts. The lawyer for the insurance company often is writing a settlement evaluation to the adjusters, and they are roundtabling this. So you need to get them all your proof, all your documentation, what your witnesses are going to say, how are you calculating damages. That way they'll come into the mediation with more authority. That goes for even when insurance is not involved. So your whole goal is to get the other side to evaluate the case like you do. And the best way to do that is to get them the information you're relying on for your narrative. So could it medical records or emails, the key texts that are going to hurt them, that type of thing is beneficial. I also want to say that with do not hide the ball, mediation, like at trial, it's great, like that smoking gun surprise. Mediation surprises can help, but they're not as effective. People don't like to be caught off guard, and oftentimes decision makers are outside the room and they haven't heard this information. So it's not as effective as it is at trial. Maybe you hold it for trial or you wait with your smoking gun to see if you're going to settle the case. But I always say mediation surprises are not the most effective technique. It's better to get them the information if you can, and if it doesn't compromise your litigation strategy. Okay, next. So other preparatory considerations for you. So I always say know about what the other side wants. What are their goals? What evidence are they relying on? What is their narrative? This is because your goal is to get as much as you can for your client from the other side. And the other side is not going to enter a deal unless they feel they are getting some sort of benefit, some sort of gain from it. Okay, they need to go back and justify it to their law partners or their colleagues or their family and friends. They need to feel the benefit of a deal. So we mediators, we want to show them the advantage, which we do, in settling rather than continuing with the litigation. You can help us mediators do so. You know the other side better than we do because we're just jumping into this for the first time. So help get us the ammunition by spending some time thinking about what the other side will be relying on, why, how, and how we can help sell this deal to the other side. Plaintiff attorneys, I want to tell you that with other preparatory considerations, you should know your insurance coverage if it's there, what the policy limits are, what the exclusions are, any coverage issues that you may have, whether I can get contribution from an insured. Issues of collectability might affect your settlement evaluation. So if the defense has nothing and there's horrible coverage, that's going to probably is going to impact your evaluation of your case. So make sure you know the coverage if they'll give it to you. Sometimes early or pre-lit, they don't give it to you, but sometimes you can get it. And you can also demand it, right? You can say, I'm not mediating unless you give it to me. So I'll leave it up to you. Know how the other side behaves in cases. So sometimes people know this attorney never goes to trial, or this attorney always goes to trial, or these are the types of verdicts they're getting. That can be helpful. That can impact your settlement evaluation of the case. And know what the other side needs from you. Ask them. So if they say, look, we want to settle, say, what do you need to evaluate this case? Do you need the text messages? Do you need a depot? Do you need, what is it that I can get to you so that you can evaluate the case more similarly to me? You wouldn't say more similarly to me, but you'd say, what do you need to evaluate this case? And try to get them what they need. That way they come into the mediation with more authority. That way they're more likely to see settlement figures similar to yours, or at least in the same range as yours. Both sides, I always say, consider making a condition to settlement that the decision makers be present in the room. Okay, so for us mediators, it is easier for us to settle the case if we have access to the decision makers, because we're trying to persuade them. We want them to hear your arguments and your positions. We want their response in real time. We want them to psychologically feel this negotiation dance and the type of gains they've gotten throughout the day. So if you think that the decision makers need to be there, I would demand it as a condition to the mediation. Now, I can tell you as a mediator, sometimes the lawyer wants to settle and the decision maker doesn't, sometimes vice versa. So keep that in mind too. Sometimes there's a benefit in them not being there if they're going to really slow it down or be unreasonable. If you have good client control, there could be a benefit, but typically it's beneficial that we have some access to them and we can have them participate in the mediation. Okay, prepare your client. So I like to tell you guys, and I do this for you anyway in a mediation, prime your client that your role in the mediation is different than a trial. So trial, you're going to discount everything they say. You're an advocate, zealous advocate, a fighter. That is fantastic. In mediation, your job's different. You are going to be a problem solver. When new information comes in, you're going to consider it and evaluate it and see if your settlement evaluation is going to change. That is a very different rule. And sometimes when lawyers feel they have to posture for their client or fight for their client, talk to us mediators if you're feeling that dynamic. I always get phone numbers right at the outset, and with Zoom, it's great. We can call you and talk to you without even your client knowing if you don't feel comfortable leaving the room. So we can do a lot of that without it. But if your client knows your role is to evaluate rather than to fight, then it takes away some of that. It makes them listen to you more and trust you more. Another thing I think that can be very helpful is if you tell your client that this can be the culminating event. So this seems so obvious that they come to a mediation. Of course, we're here to resolve it. People who've been living with a dispute for a lot of years, they may be thinking about this literally all the time. And they may be very emotional about this. And they sometimes are not ready to put this behind them. It's happening too fast. The numbers are moving. They're feeling stressed. And we got to get them psychologically there. So as mediators, we can help you with that. And as well as you could talk to your client about that as well. Okay. Another thing I think we should tell your clients, and I always tell your clients, is everything that's happening in a mediation is a negotiation strategy until the end, the last number I can get you. So when somebody has a catastrophic loss and the insurance comes in with $50,000, that is emotionally can be very difficult for a plaintiff. And vice versa. I mean, we have cross claims and it can be difficult for defense too. So I always say, look, it doesn't matter until the very end. All of this is strategy. Everybody calculating midpoints and looking how to squeeze the most they can on it. The end is what matters. And so I'm going to tell your client that, and hopefully your mediators are telling your clients that, but you should also tell your clients that so they can take a deep breath. They can go through the process without a lot of concern and stress. Another thing I think you should tell your client is you want to minimize, combative listening. So combative listening is when somebody can barely even hear it. They're so busy defending their position, right? And it's just, no, I didn't do that. And I can't even get out my whole sentence before they tell me that. That's very normal for what it's worth. If somebody were telling me I did something that I knew I didn't do, I'd want to jump in and say, that's not true. So it's very hard to sit still. So it's not a big deal that they don't, but it is more productive if everybody listens to what I'm saying. You can take your notes because there's a lot of value in what I'm talking about and how I'm talking about it and when I'm talking about it, because that's what the other side is doing. So that's giving you a big tip on what's going to happen in litigation, right, in trial. So if they can just try not to interrupt, listen, and then I say, okay, I want to open it up to you. And then we work together to fashion a response. If you can do that, that takes away some of the defensiveness. And I just gently help with that as well. But some of that maybe you could say to your client. And I know a lot of you do say that to your client because I come in and everybody's quiet. So I think it is helpful for what it's worth. And then this is so obvious, connectivity issues with Zoom. We're now, 5 years into this, and we have less problems with it, but I'm still having problems with some of your clients. Once in a while with you lawyers too. Just make sure, if you have a half day with me, it can slow us down. I try to work around it, obviously, but if your client's in and out and then they're not hearing things and then they're out for a half an hour, it makes it difficult. So maybe do a practice run, make sure they have internet, otherwise bring them into your office. I love when you come into our offices. I know a lot of us mediators love in person, so that's always an option as well. Okay, and then lastly on this slide is sharing mediation brief. So this is a topic unto itself. I did this year, or a couple months ago, I think, an hour program on mediation briefs and what should be in it and whether to share it. Most of us mediators believe that you should share your mediation brief. We think it actually strengthens your position at the mediation because the other side is hearing your case. They're not hearing it the first time through me, they're analyzing it, and then they likely will come in with more authority when they know how you're putting this all together. Now, some lawyers say they already know we're late in the litigation. That's not always the case, even when you're late in the litigation, because you haven't had those direct conversations about the strengths of your case and why you think it deserves to be settled at X amount. What to put in your brief? Look, I'd say don't put if you're sharing, obviously don't put antagonistic remarks. Why insult the person you're trying to get something from? If you're giving me hundreds of pages of exhibits, that's so challenging. Highlight for me the portions that you want me to read. I love when you put photos and the key testimony in the body of the brief. I think that can be helpful. You can give me information you don't give to the other side. So when you share your brief, I wouldn't give them your goals. I wouldn't give them your numbers. I would just give them your position and why you think your case is so strong. In a separate memo, you can do it in an email, you can do a different brief to me. You can give that type of information that you want to preserve from the other side for litigation strategy, right? So you can still give it to me. I know that a lot of you lawyers out in Zoom land right now do not want to share your briefs, do not like to, and that's perfectly fine with me. I work, it's your case. I'm just here to help. So I respect that. Just having said that, couple more reasons to share your brief. It saves time. Half-day mediations. I know some mediators, I don't do this, but some mediators actually require you to share briefs if you're doing half-day. There's just not enough time to get all that information to one another. Cognitive biases. People have biases that prevent them from hearing new information, and they'll just discount the information if they've never heard it before. They'll say, I just had this yesterday. I've never heard this before. I'm not considering it for settlement. So that does happen frequently enough that I would say we got to get them this information before. And also decision makers are outside the room oftentimes. Certainly insurance companies, the city, the top gun at the city oftentimes isn't in the room. School boards, I have boards all the time that aren't in the room. Don't you want them to see it and come in, give you more authority at the outset? Same with you on the defense side, plaintiffs. There might be support people. They may have a father, brother, friend who is an expert in this area or a lawyer, and don't you want them to take a look at it and help you with your evaluation as well before they get to the mediation? So I encourage it, both sides. Even if one side's not sharing, please consider sharing. All right, next slide, please. I think it is great to collect information about similar situations. So I told you similar verdicts and settlements, similar values of property, similar valuations of businesses, similar treatment of others. If other employees have sued, if other tenants have sued, how have they been treated? This is all very helpful. It is helpful because it gives you power in the negotiation, it gives you information power. It is also helpful because cognitively biased people, when they discount information contrary to the beliefs. If they think the light was green and you say it's red, they're going to discount it. They don't discount in the same way analogous situations. They actually can slow down and think about that. So social science experiments have shown that analogies actually can help. And that is a really great thing. So when you have similar situations. It has persuasive impact. If you show the other side all the settlements that are for $700,000, that's going to be beneficial. It also can help so that others can say, oh, other people are settling for $700,000. Now, this also there's a cognitive bias called the bandwagon effect. And this bias is that people like to do what other people are doing. A social scientist named Robert Cialdini also does this, and he calls it like consensus and social proof. And he talks about persuasion techniques. Doing what everyone else is doing people like that. They feel comfortable with that. So this similar situation, I'm telling you, I think in these mediations, I think it can really help. So consider bringing that as well. All right, next slide, please. So as your mediator, I get concerned about earlier settlement discussions. And the reason I do is because even if you're earnestly trying to settle your case, you are creating a floor or a ceiling to the negotiation. So if the adjuster thinks like they're being really reasonable and they're offering $1 million on this case, and the plaintiff says, no, let's go to mediation. Now the adjuster doesn't have much room to move. They actually gave you a real number, and the same vice versa. So what happens is everybody wants you to start at the mediation at the earlier numbers given, or they think it's bad faith. I hear the word bad faith and good faith a lot as a mediator, but they'll say it's bad faith. Now, somebody may say, I spent more attorney's fees, so I'm going a higher number. But then the defense says, well, I did too. So then I should go down. And so it's creating an expectation of that as a start point. Please know that. So please be careful. If you know you're mediating, please be careful about earlier numbers. And if you're having a second mediation, stop short. If it's not going to settle because the defense needs a deposition, or it's not going to settle because plaintiff needs something, or we need to bring in new parties, stop short. Don't create floors and ceilings until we get more information. So just please be careful with that dynamic and going backwards. So if you offered aid to take 80,000 and now you're demanding 500,000, why? And sometimes there's a really good reason why, because they want, they knocked out some claims or something else happened or a witness gave some great testimony. But without that, please be careful of these backward steps. Next slide, please. Okay, pros and cons to remote mediation. I think we mostly know this, but let me just run through it. It seems like the default is Zoom mediation. We're very effective with that. I think settlement rates are the same with Zoom. It's efficient for lawyers and their clients. We get more decision makers present. So I'll have people from around the world in the mediations. It's fantastic. I have people, like I did one for a school, and I had the principal and the teachers coming in and out. I had school board members coming in and out of the mediation. They can go back to their job. And when I get back in the room, they can come back into the mediation. People are less stressed in the comfort of their environment. We can still read all the nonverbal communication from chest up. So that's good. Telephone's tough because we can't see your facial expressions and your body language. So it works. It's a great tool for mediation. Some of the cons is people are not investing the same time and energy sometimes. So I've been at water polo practice, ballet recitals, on the freeway in traffic. I went to a doctor's appointment a month ago. So the people are doing their normal lives and they're not investing. And that makes it harder to settle than if they're in my office or on the Zoom in one place. The other thing is they've done studies on this now, and they look in the context of psychology and therapy, and they find that it's better for people to be in person, that there's more connectivity, and that's important too, right? Like I have more persuasive impact in person. We're good enough on Zoom, but if you have a really tricky case or a sad client or a nervous client, that personal touch can really be helpful. So I love when you guys come into the office. We serve cookies and lunch and all these we have lovely conference rooms at ADR services. So I encourage it, but if you can't do it and it works for you, which it seems most people are preferring Zoom these days, but just it's worth giving it a little thought of the dynamic of your case and how we can be helpful. Okay, next slide, please. So as a matter of practice, I do pre-mediation phone calls, and I feel that these are very advantageous for our mediation before we get there. I am not looking for you to argue your case to me because I'm going to read your brief twice. I'm going to read it the day before and I'm going to read it the morning of. So I'm not looking for that. What I'm looking for are tricky dynamics. Paths and obstacles to settlement, your relationship with your client or opposing counsel, and what you've noticed over there. I shouldn't say or should say, or how if we have several policies, how they're working together. Should I have them in the same room or different rooms? If your client has no money, I'm going to want you to, before the mediation, start getting financial documents to show that, because that could impact plaintiff's settlement evaluation, right? There's so many things that we can talk about, the whys, the goals, that can just get us started on the right foot and make sure that I'm doing what needs to be done for the mediation. So all these heads up you can give to us mediators, they are really helpful. What you're telling us, it may not feel like a big deal, but sometimes it really makes a difference. So I encourage you to speak with your mediator. If your mediator is not emailing you the morning before and trying to reach out to you or calling you, I think it can always be advantageous. Okay, next slide, please. Play nice with opposing counsel. So I love this shirt. I don't know if you can see it, our Get Along shirt. I should stick my children in it because they used to fight so much that I think if they were like connected like this, maybe they wouldn't fight so much. I say this, it's so obvious, and you're probably already had programming on civility. If you haven't yet, you will. Besides civility, take that aside. You do a better job for your client if you play nice with opposing counsel. So if you're respectful and professional and cordial, this is helpful because people give things to people they like. So Robert Cialdini, a social scientist, did experiments. He looked at women in a Tupperware party, bought the most Tupperware from the Tupperware salesperson they liked. Now, this experiment has been done countless times since then, and they all support people give things to people they like. So be appreciative, be respectful, give discovery extensions when they need it, coordinate deposition dates, don't file a motion on the weekend of their wedding, like basic things. If you come in with this relationship, now as a mediator, I can tell you, I see the benefit of it. So while you're in the mediation, I do all your likability things, for you. I make messages nice and productive and collaborative. Outside the mediation, I can't before you get to me. But keep this in mind that you're trying to get from them as much as you can possibly get from them. I saw a lawyer the other day say, you know what, plaintiff's counsel is really honest guy. He's a good guy. And if he's evaluating the case at this number, we should take it. I was like, wow. That was amazing. I thought that. I didn't say that. On the other side, I've seen defense say, I don't like this contingency. They use harsher words than I don't like. This contingency fee lawyer, and he's going to get 40%. No way. I'm not giving another penny. Okay, so it seems so obvious, but I just want to bring it up because I know a lot of you have trouble with your relationships with opposing counsel. Okay, next slide. Mediation day. My slide is meant to show like this is the big event. I think it's so powerful. All right, so now we get to the mediation. You are prepared. You are ready to go. Your client is prepared. So let's jump into the mediation, next slide, and talk about how we're going to optimize our outcomes for our clients once we get there. So first thing that often people ask me is, where should I start? Sometimes they don't ask me, they have their own ideas about where to just start. And this, I call it an anchoring number. This is the first offer and the first demand given. This is what starts our negotiation. Now, why I call it anchoring number is because there is a bias called anchoring bias, and there's social science experiments talking about anchoring. They both say that people look at the reasonableness of a number based on an earlier number given. Now, most of you lawyers understand this conceptually. And you say, I'm going to start really high or really low because I don't want them to expect that I'm going to settle in 5 figures. I'm making this up, obviously. So I want to start really high to send this message. Okay. And then the defense, when they get the really high, they say, well, I'm going to start really low to tell them they're just out of the ballpark, in outer space, or whatever phrase. I get a lot of different phrases on this, that they are. Okay, so great, I understand. So if, let's say somebody went to a store and it said jacket, $1,000 on sale for $500, you are more, the science experiments show you are more inclined to buy that jacket than if it just was $500, okay? So there's a lot to this, and I think you should work with this. It is a good strategy. So you want to start high so that at the end, or low, depending what side you're on, at the end, the other side feels value in your move. They feel you've made compromise. They feel like they've gotten a gain. And if you start at $1 million and you settle for 250,000, they say, wow, I've got a deal here. Some of you say, well, they could start at 10 million. That's out of the park. It doesn't matter. It's not real money, all of that. And that's true too, for what it's worth. Okay. But you don't want to go so high, so extreme, so high or so low that you insult the other party. Why? Because then they engage in negative negotiating behavior. They are insulted. So it's the opposite of the earlier slide where you want likability and you want them to give you what you're asking for. And now they're mad and they're insulted and they don't want to give you what you're asking for. Okay. Not to mention you prolong the mediation and whatnot, but that's a whole nother issue because we can speed you up as we go along. Okay. So what my advice is, you want to create the anchor effect, right? And get them to feel the gain. But you want to find the sweet spot. You want to be high enough that you give yourself space with concessions, but not so high that you create this insult. And that is a really important distinction. Now, having said this, I want to also say, don't worry with extreme anchors. Cases do not resolve at the midpoint of the anchors. They tend to resolve somewhere in the midpoint area of the first reasonable offer and demand. And the social science shows that the party that makes the first reasonable offer or demand is the party with the negotiation advantage. So I would encourage you to get to reasonable numbers first, so that you get that advantage. If you want to go super extreme and we can't talk you out of it, then you want to attach it a lot of times to damage calculations. Then they see, okay, 500,000 of this is attorney's fees, so I know I have some wiggle room here. And they may not respond as, all this is emotional distress. Okay. And it tends to calm down the other side receiving an extreme anchor. Who goes first with the anchor? Typically it's plaintiff because they brought the lawsuit, they're making the demand. Sometimes there's an advantage for the defendant to do it. I don't personally think it matters. I've watched this over the last 10 years to see. I don't see there being an advantage of going first or going second. I think defendants like to go second especially if they're doing midpoint calculations. So when they have out their calculators or doing the math in their head, trying to find midpoints, they tend to like to go second so they can maintain a midpoint. However, if you're maintaining your midpoint, also be aware that you're messaging entirely to plaintiff where you're going. So if you've done 3 moves with the same midpoint, that is a message. So you may want to, if you don't want them to know, you may want to disguise that a little bit. I don't think it's bad that they know that, I should just say. But with the midpoints, be careful. Practically speaking, I don't really care about the anchor. I have never had someone walk out of a mediation. It's pretty normal that people go extreme. And I normalize and remind them it's the last number that matters. All of the other stuff is negotiation strategy. It doesn't mean anything. It doesn't mean anything to the client because what the client cares about is the end deal. So keep that in mind. All right, next slide, please. Okay, concessions. So concessions are your compromises, right? After you make your initial move, now what should you do? How are you going to get the best outcome for your client? So a couple things to remember. The pattern of your concession sends a message. So if you start at 5 million and you drop, this happened to me. The case actually was a dog bite case. It settled for 60,000. Plaintiff started at 5 million and settled at 60,000. And her first jump was $750,000. That is not a great pattern of concessions. It would have been much better to start at a reasonable number and make smaller concessions. Be aware the other side's reading your concessions. They typically ask me to try to read your concessions. And every concession's sending a message. When I teach mediation to both mediators and in my class, I usually refer to this phase as the negotiation dance. And that's just because the other side is your negotiation partner. And what you do informs the other side what they're going to do. So if they make a big move, the other side makes a big move. If they make a little move, the other side's going to match you and do a little move. So just keep that in mind. This is also the concept of rule of reciprocity. I've written about this if you want to check out my website about these social science persuasive techniques that you can use. But it basically says people repay a favor with a favor of equal or greater value. So if you make a generous move, like as a mediator, I say, look how big of a move this is. It's so generous. Let's reward this. If they don't reward this, then you can always go to a small move to tell them you didn't like that they didn't reward this. But typically people want to reward this and move towards productive conversations. If you're so negative and little, you get in this negative reciprocal pattern of negotiation. That is not good. We can get you out of it, but let us get you out of it because now everyone's insulting and upsetting and no one really wants to go forward. And I hear they're not in good faith. And so be aware of that. Okay, I've seen this, and maybe because I teach negotiation, I'm extra interested in it, where people are making concessions with money, and all of a sudden one side stops and switches to creative solutions. And all of a sudden, the other side just assumes they're out of money. And I don't know if they're out of money or not, but the other side's making that assumption. So you may want to try that. If you have, let's throw it in the employment context, you stop and now you're talking about a positive recommendation or some creative component that you could offer training to your employers or put them in a different office or whatever it may be, they may think there's no more money to be had. So you might want to try it. You could maybe get some traction there. If it works for you, let me know. I'm interested in that. I love this stuff. I always say never give a concession without getting one in return. So sometimes I'll come in and one side says, they have not moved. I'm not going to move till they get under $1 million. This is ridiculous. I'm not doing it. I'm not responding. Okay, don't let them do that. As a mediator, I don't let that happen. I say, just make a small move. They're not going to negotiate against themselves. I'll send the message that you're unhappy, that you'd like them to get under $1 million. But don't make a move and then another move without getting something back. That gives them extreme power because you just listen to them on that. And it's not, I don't think it's good. I don't like it in my mediation, so I try not to allow it. All right. Defendants like to talk about percentage of moves. So you're always so a plaintiff could drop 500,000 and you could move up 5,000 from 5,000 to 10,000. You say, I made 100% move. They only made a 30% move, something like that. The percent is always on your side. So defendants love it. You could have your mediator carry it, see if it has any impact. It's obvious the percentage is always going to be in your favor, but all the power to you on that. Plaintiffs, you usually have the benefit that you're making bigger monetary jumps. And so you can try to sell with that. So defense likes to talk about percentage move. Plaintiffs like to talk about monetary move. We can carry those messages for you to see if it has any impact for you. Okay, so there is another social science. So I keep bringing up social science because there's books on how to get people to give you what you want, right? And so that's what this is all about. This Robert Cialdini, Science of Influence and Persuasion book is great because it's all about how to get people to give you what you want. And then there's all these other books without people even knowing you're getting them to do this. I love this stuff. One thing that Robert Cialdini talks about is triggers, which is you're more likely to get your request if you accompany it with information. So let's just say you needed to cut the line. Your baby's at home and your babysitter has to go and your baby has a fever and you need to bring home the medicine and save the baby. If you just cut in line, everybody could be very upset with you. But if you explain this to them, they're more likely to understand this and let you cut. It's the same thing in mediation. When I'm trying to extract a concession and get a compromise, I'm carrying over information. Now, one thing I want to say, information management matters, because if I give them 1,000 reasons why you win your case, they will only focus on reason 1,000, your weakest argument, and tell me why it's so weak. So I like to parcel out information and manage your information. If your mediator is not doing that for you, then maybe you hold the information and you parcel it out yourself so that you don't dilute your argument. We all remember law school argument dilution. So we don't want to do that. Okay. Please, please, please save some concessions for the end. We know that we mediators assume you have more to give. And typically it's great and lovely when you just come to a nice agreement and your evaluations overlapped and everybody just moved to a point. Typically what happens is I have a gap that I have to bridge. And I need to bridge this by either creative resolutions or getting everyone to move a little further. So save some room. Tell me you're done when you're not. And then give me a little more to bridge the gap. I also like you to save some room because the other side wants to feel they got the very best deal possible. They want to feel you stretched past where you want to give. And so if you save a little information to the end, a little concession, you call it when you know you have another 50, 100, 25, whatever it is, then they may feel that stretch and emotionally, psychologically be able to get there.
Stacie, before you move on, could you say once more the name of that negotiation book you referenced?
Yes, it's Robert Cialdini, and it's called Science of Influence and Persuasion. And it's a funky spelling. It's Cialdini. And I love this book so much. I actually have my advanced negotiation and mediation classes read it because I just think it's so helpful. Mediators, we're in the field of persuasion, but you are also. We all negotiate throughout our lives with everyone, both not just opposing counsel, but in our lives. So I really think this is a helpful book. And there's also John Barg. He wrote a book called Unconscious Influences. I think that's fantastic too. Okay, next slide. All right, mediator communications. Look, we work for you, with you in the mediation. I am very cognizant that if you don't settle, you have to go to trial, and I never want to interfere with that. So I'm very communicative. Sometimes I'll say, how do you want me to say this? Because there's some risk in it, or can I say this or whatnot? Just be very communicative with your mediator. Ask your mediator, what is the emotional temperature in the other room? What are the dynamics? Like, who's talking? Sometimes it's the client totally talking. What do we think about the clients and the parties? We do this every single day. I do this every day. So I am used to negotiation strategies and what people are saying, whatnot. So ask us, we can help you with all of this. So be pretty as communicative. Also, if there's some component you need in your deal, this happens a lot. And otherwise, you can't make a deal even if you get to the monetary or whatever the situation may be. Some like funky or unique component. You should talk to your mediator about that at the outset and discuss with them when's the best time to bring it up. Should we just talk about it at the outset? Should we wait till we get some traction? Should we save it for the end once we get to settlement? Once people get to settlement, they're less likely to derail a negotiation based on a smaller offshoot type of issue. So talk with us. I like to get some traction going and then bring it up, but sometimes it's important we get it out right at the beginning if it's a deal breaker. So please be communicative. Okay, next slide, please. Should you reveal your bottom line to the mediator? I don't think it's a great strategy to come in and just tell us your bottom line, because we may be able to do better than that for you. And we hear that and have us work to get you the best deal we can get you. And also, and I hate to say this, don't tell me your true bottom line, because I'm going to assume you have a little more room to move. Most people don't tell me their true number. So give some fudge room, give some wiggle room in case we can't get the other side to take it. And that does better for your client, because if your client's bottom line, they'll pay 200,000, you say it's 100,000 and I can get you that, that's so much better for your client. All right, next slide. So we have a bunch of tools to help bridge impasse here. So when you guys are at these extremes, let's say one's at 1 million, the other's at 5,000, and then everyone wants to move in increments of 1,000 or 5,000 because they're so mad at the other side. Let us work with you. A lot of times while you're monkeying around at these extreme numbers that could never settle, I can behind the scenes get you settled with the what ifs, because it's on me. So it's not changing your negotiation floor and ceiling, and it's allowing me to get your case settled. So it looks let's say the case could sell at 250. I'd say, what if I could get them into 6 figures? Would you take that? What if I could get them with a 2 in front of it? Would you take that? And they'd say, well, yeah, but they're not. They're obviously messaging 5. Well, let me see what I could, these what ifs are such a strong mediator strategy. And when I train mediators, I actually spend like half an hour to an hour on it, because it's how we say it, what we say, when we say it, can really get us to settlement, even when you're at these extremes. So keep that in mind, work with your mediator in that way. Brackets, I love them. Some of you lawyers hate them. They're not necessary if everybody's engaging in productive negotiating behavior. It's very helpful when you're scared to move, because because the other side isn't. It's a simultaneous jump, and that gives people more comfort. So it can work in several ways. One is I propose a bracket, say the case is going to settle at, I think it's going to settle in the 2 somewhere. I say, how about we do a bracket of 75 to 5 or 1 to 3 or whatever it may be. I do my own calculation. If everyone gets in it, great. We're in a reasonable range of settlement. I'm going to settle this case. If they don't want to do that, then sometimes they propose a bracket and we start negotiating with counter brackets. Great too. Keep in mind, though, when you're doing this, it's the midpoint of the bracket that we're reading. So if you're at 5 and you've moved to 10 and you want to settle at 250, maybe your first bracket as a defendant you offer is 50 to 100. Now you're messaging 75. That's a great move. That would make the $1 million person give you, maybe they're going to go 4 to 6 with a message of 500. Now we're cooking. Now we're productive, and we can keep counter bracket messaging. Sometimes I say to everyone, if I can get the other side to use their midpoint, can we just go back to hard numbers? Typically they say yes. Sometimes I can settle at the midpoints of the bracket. This really helps us get settled, and it certainly gets us into that reasonable range so we can explore whether we can get it settled. And then with mediators' proposals, I know you all are familiar with these. Remember, it's settlement value. It's a phenomenal tool when a decision maker is out of the room because you don't compromise your negotiation position. You're at 200, even if my proposal is for 600, they don't know if you said yes or no unless they did. And that's a real value to these proposals. I try to only use them if my decision makers are out of the room or if somebody needs to explore information that they learned. So let's say you say, this building is valued at X amount. Well, they may need some time to do their own appraisal of the building, and so I can hold open the mediator's proposal, or maybe they need board approval. Those types of things, the mediator's proposal can be very advantageous. So consider letting us do that when we're not in the room. It's a great tool for bridging any impasse that we may have. I always put a time component. Ask your mediator to put a time component. There are social science studies with the scarcity of time. The urgency makes people more inclined to take an offer. So you want to say today's your chance to get this case settled, and go from there. Okay, next slide, please. We can bridge impasse with creative resolutions. You can trade off priority of interests. You can also trade off, create win-wins. So, trade off priority, maybe you share an office space with another company and you need another parking space that they're not using, and they want the joint area for cocktail parties on Friday afternoons. Great. Trade-off priority of interest. Win-wins like joint press release, future work together, things like that can be very beneficial. Talk with us. We do this every day. We're going to have great suggestions. You also and your clients can help. Like I did a steel fabrication business mediation. And that's a new industry for me, but with the help, we had such great creative resolutions with everybody. So keep this in mind, work with us. Also, objective frameworks work. I had an insurance commissions case. We had thousands of numbers and documents. We got in an accountant to help decipher the numbers, and then you created a reasonable range for mediation based on the accountant's determination that everyone agreed on. We can use it with appraisals, we can use it with realtors, things like that. So this can be very, very helpful for us in getting to settlement, and payment plans. They help. Structured settlements, they help too. So work with us. We'll all get there together in finding creative resolutions to bridge impasse. Next, sorry. I've covered this slide, so next, please. Okay, after the mediation. So I just want to say a few things about after the mediation, how to protect your client. So look, if you settle the case, please, 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 please put it in writing, get a signature. Every single mediator. I am a member of this International Academy of Mediators, which is an amazing organization. We talk about this stuff, these horror stories, when people don't put it in writing. We all have nightmare situations that have cost people's clients hundreds of thousands of dollars because they didn't sign the deal. People sleep on it and they consider, could I have done better? Why did the other side agree to this? Maybe I should have gone there. I forgot to bring up this point. I forgot to ask for this. Get it in writing, signed. So we at ADR have services have a short form agreement. I get it to the lawyers digitally. It takes 5 minutes to fill out. Great if you work on a long form. Sometimes I actually start working on it during the mediation. That makes you collaborative, but also it gets us so we can have a signature relatively quickly. And we could even start exchanging. Some people bring a long form. I love that. I recommend it. Rarely does it happen, where you've negotiated all the terms and all we have to do is plug in the settlement terms we've been negotiating. So all of this can be so beneficial for you. Short forms are great, long forms better, because then you're done. Very least, let me put this in a congratulatory email with the terms of settlement, and lawyers confirm. Now, I don't know if this holds up at court. I really don't. But it's better than nothing. And I know lawyers can bind their clients, but I don't know in this format if they do or they don't. So let's try to get client signature. I stay with you. I'll sit here with you until we get this signed so that if any terms come up that hadn't been negotiated that we need to get through, I can help you with that. If you leave the mediation and you want to do it on your own, CCS mediators, I'm watching the communications. If they're getting bad and you're stuck, I just jump in and try to help you guys get us there. So please keep that in mind. We want to waive confidentiality and section 664.6 court retained jurisdiction. Can I say one more slide, Katie, or are we done?
Yes, absolutely. I just wanted to let you know we're right at our time here. If you want to wrap up with one final comment or slide, that'd be great.
Okay. I just want to say one more thing with settlement agreements. Well, if you guys are interested in that, I know we're out of time, but with settlement agreements, if you're relying on something someone says, please put it in your recitals. So let's say someone says, I have no insurance. So you take 100,000 when you wanted 800,000, put it in the recitals, because unlike normal life where fraud and the inducement with the contract, you can't prove it because mediation is confidential and you waive confidentiality only as to the four corners of the agreement. Now, you can't waive confidentiality for the whole mediation. So please put in the recitals so that you're protected. Payment plan, plaintiffs, do a cure period and have the defense have to trigger it, give you notice so that you have a chance. And defense, I do a stipulation for entry of judgment or liquidated damages to protect your client with any payment plan you use. Okay, and finally, I just want to say, look, settlements are never a waste of time. You just haven't settled yet. 95% of cases settle. So, take the information you learn. This is one step closer. Try not to interfere with later efforts by doing something drastic, and just keep in mind we'll stick with you. I always stick with you and try to get your case settled. All right. Sorry I ran out of time, everybody. Thank you so much for your attention to this, and I hope there were some nuggets in here that you found helpful. Oh, and I'm getting emojis.
Yes, you see all of the emojis. Thank you so much, Stacie, for that great program.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.